California attorney has a duty both to his client and to the legal system to represent his client within the bounds of the law. This is how our system works. It helps to define advocacy, and it helps to explain why cases that outside observers might think are absolutely winnable or questionably defendable become hard-fought battlegrounds over facts and law. An example of such vigorous advocacy is evident in a recent California Court of Appeal case. A lower court in a California elder financial abuse case denies the protections of the California Elder Abuse Act. The couple appeals the ruling to the higher court. I omit the actual names of both the couple and the defendants in this commentary. This case is being returned to the lower court, and the evidence in the case has not yet been presented to a judge or jury. So the Court of Appeal synthesizes the alleged facts of the case as follows. A few decades ago, husband and wife purchased 2 life insurance policies, naming their children as beneficiaries. The policy's combined death benefit is approximately $1 million. The annual premium cost is $14,000. The couple's revocable trust owns one policy, and a daughter owns the other. The couple advances enough money to the trust and to their daughter to pay the annual $14,000 premium. In 2013, husband, age 82, and at the end of his career as a lawyer, is suffering from confusion and cognitive decline. Wife, at the same time, has already relinquished control over the couple's affairs to the husband by a power of attorney. Wife is diagnosed with Alzheimer's and is even in a more precarious state of health. The lawsuit alleges that an insurance agent, his agency, and an insurance brokerage network seize on this situation and allegedly carry out an elaborate scheme that involves arranging the surrender of one of the existing life insurance policies and the replacement of the other with a policy providing more limited coverage at massively increased cost. The premiums for the new coverage are spread out over the term that it's to be in force, and that amounts to some $800,000. This forces the elderly couple to feed cash into the trust to sustain it, and in effect consumes most of their intended $1 million gift in transaction cost, including $100,000 in commissions to the insurance agent, his agency, and an insurance brokerage firm. So if this case ultimately goes to a judge or a jury trial, what evidence would the plaintiffs present? Well, it's a fair assumption that if the plaintiffs have the evidence alleged in the lawsuit, the elements of their case would likely be: husband and wife have an insurance plan in place for over 2 decades to provide $1 million death benefit to their children. The annual cost for this plan benefit is $14,000. An expert testifies that husband is suffering from confusion and cognitive decline. An expert also testifies that wife has Alzheimer's and has relinquished control of the couple's affairs to her husband. The insurance defendants meet with husband and wife at their home and convince them of their insurance expertise and that they have the couple's best interest at heart. The insurance agents offer to review and fine-tune the insurance policy part of the couple's estate plan. The insurance agents are aware of the couple's cognitive decline and the wife's Alzheimer's. The agents review the life insurance policy and find that one policy has a death benefit of $600,000 with an annual premium of $6,000. The other policy has a death benefit of $540,000 with an annual premium of $8,000. The couple's daughter owns one policy and the couple's revocable trust owns the other policy. The insurance agents tell husband he could use the cash value in the existing policies to get substantial additional coverage while keeping the annual premium cost at $14,000. The insurance agents deal only with the husband and cut the daughter out of any discussions and limit her access to information. She's given signature pages of blank forms to sign. The insurance agents try to get replacement coverage for the couple, but coverage is denied because of wife's cognitive disorder and abnormal lab results for husband. Insurance agents then try to get a new policy insurance only for husband. The insurance agents, through a series of misrepresentations to husband and the life insurance company, have husband borrow money from a policy and apply a surrender value from another policy to purchase a new life insurance policy. The new policy has a death benefit of almost $1.2 million, but requires an initial payment of around $250,000 and an annual premium of $100,000. The policy terminates on husband's 91st birthday. The result to the family is the trust is drained of cash, and the trust is obligated to pay over $1 million in additional premiums. So much of the battleground of this case involves the interpretation of a statute, and the statute at issue is the California Elder Abuse Act. The defense lawyers agree that husband and wife are elders under the act, but argue that the couple is not deprived of any property. The appellate court says, although we are skeptical of such a stingy reading of the statutory text, the position the respondents, that is the insurance defendants, take does have some surface appeal. The court then addresses issues beyond the surface appeal. While this commentary is not a law review or a brief, and all the intricacies of the Elder Abuse Act are not going to be addressed, we can hit some of the Act's highlights. The legislature recognizes that elders are a class of persons who are particularly vulnerable to abuse, and that this state has a responsibility to protect them. The Elder Abuse Act protects elders by providing heightened remedies that encourage private enforcement of laws against abuse and neglect. Attorneys' fees and cost awards are available for financial abuse claims proved by the preponderance of the evidence. In 2008, the legislature replaced the prior requirement that bad faith be shown with a standard based on whether the defendant knew or should have known of a likely harm to the elder. The legislature also redefined the phrase takes, secretes, appropriates, obtains, or retains so that any deprivation of property was subject to liability, including by means of agreement, donative transfer, or testamentary bequest, and regardless of whether the property is held directly by the elder or on his behalf by a third party, and created a new basis for liability, adding deprivation of property by undue influence as a ground for suit separate from deprivation or wrongful use or with intent to defraud. So let's get to the essence of how the Court of Appeal analyzed the plaintiff's first amended complaint. The court looked to whether deprivation committed by undue influence is actionable. The court notes deprivation committed by undue influence is an alternative basis for liability to deprivation by wrongful use or intent to defraud under the revised liability scheme created by amendment to the Elder Abuse Act in 2008. The court says the first amended complaint sufficiently alleges the elderly couple felt need to pay more into the trust to keep it afloat, and that this was brought about by undue influence as now defined in a new code section. The defendants are alleged to have taken advantage of two aged individuals, both in a state of cognitive decline, and by use of their professed expertise as insurance professionals carried out an elaborate plan of replacing insurance on the victims' lives by actions or tactics that included haste or secrecy, ultimately visiting serious inequity on them, which included adverse economic consequences, divergence from their prior intent, and commissions paid that are out of proportion to the value of the services rendered to them. The court notes that the defendants are free to argue in their defense that factually and as a matter of causation, the couple's actions in paying more money into the trust were volitional and somehow independent of their alleged bad acts. But for now, the first amended complaint sets forth plenty to permit a finding to the contrary. So what does all of this really say? Well, it confirms our experience that when we file elder financial abuse cases, we're really in for a fight. Defendants with capable counsel will represent their clients within the bounds of the law. We expect this. The court also makes clear that the language of the statute means what it says. A person or entity takes, secretes, appropriates, obtains, or retains real or personal property when an elder or dependent adult is deprived of any property right, including by means of an agreement, donative transfer, or testamentary bequest, regardless of whether the property is held directly or by a representative of an elder or dependent adult. We're committed to upholding the rights of elders victimized by elder financial abuse, and we do so in the major urban counties of California, including Los Angeles, Alameda, Santa Clara, and Sacramento. If you'd like to speak with us about an elder financial abuse claim, call us at Hackard Law, 916-313-3030. Thank you.